Hello. My name is Naomi Kikoler, and I'm the Director of Policy and Advocacy with the Global Center for the Responsibility to Protect. I'd like to thank all of you for coming to this panel, but also to thank the Cardozo Law School and also the Auschwitz Institute for organizing this kind of phenomenal discussion today that's very timely and also very practical, which is great for those of us who are working to try to advance support for genocide prevention and the responsibility to protect. We have a really fascinating discussion ahead on transitional justice and genocide prevention. 4 excellent panelists. So I just want to quickly give you an overview in terms of how we're going to proceed. Each of the panelists will speak for roughly 10 to 15 minutes, and then we'll open it up for a discussion. And then at the end, we'll close with a wrap-up similar to the last session, where each of the panelists can provide some concluding thoughts on this particular issue. So let's get right into it. I'd like to introduce Professor Elazar Barkan. Professor Barkan is a professor of international and public affairs at Columbia University. He's the director of the School of International and Public Affairs Human Rights Concentration and the director of Columbia's Institute for the Study of Human Rights. Professor Barkan is also the founding director of the Institute for Historical Justice and Reconciliation in The Hague. Professor Barkan's research interests focus on human rights and on the role of history in contemporary society and politics and the response to gross historical crimes and injustices. His recent books include No Return, No Refuge, Rights and Minority Repatriation, and also The Guilt of Nations, Restitution and Negotiating Historical Injustices. Professor Barkan.
Good morning. Thank you very much for the kind invitation, and I'm obviously very delighted to be here. What I'm going to do in the next few minutes is just raise a few points that we can perhaps discuss later. The first is that I want to point out for the dissonance between the tools of prevention and what we have had as a wonderful discussion earlier, but also the actual frustration that in the non-professional, outside the inside baseball that is being played within professionals with the UN, that there is a great deal of sense of failure about the sense of protection. That looking at Syria and the fact that for 2 years practically nothing effective is being implemented in terms of stopping the violence is perhaps has not received as much of an attention when we talk about the tools and the culture of prevention and the new horizon that is feasible for responsibility to protect. So I think that the first thing that we need to is also see the way that it is being viewed in the wider perspective. Now I want to say 3 things about transitional justice, which with regard to conflict resolution. And obviously transitional justice has done tremendously good and has a tremendously good impact on a lot of process of democratizations, and we are going to hear about it. And most of us are working in it in one direction or another, so we are aware of a lot of it. But I'd like to point for 3 critical points that need to be thought of in terms of the relations of transitional justice to conflict resolution. Transitional justice is very appropriate for questions of democratization. But when it comes to questions of truth, there is a problem. And the problem is that I'd like to frame it through Francis Deng's comment about the issue of, about the way that he described his task as managing diversity. Transitional justice does not pay a lot of attention to managing diversity. The questions of truth is one that is being elicited through testimonies of victims, primarily, through trials, and with the goal of reaching a truth that actually is comprehensive and correct to all parties that are involved. It pays less attention to the multiple truths that exists in conflict resolution. And in academic research, when you think about transitional justice, there is no division between transitional justice as it applies to conflict situation and to a process of democratization. So the whole notions of what's the impact of transitional justice on establishing diversity, coexistence of groups that emerge from conflict is much less developed. The other point with transitional justice, which needs to develop further, is the conversations about the role of victims in post-conflict situations. By and large, we have no moral critical lens in which to look at victim suffering. We have a lot of empathy, justified empathy, for victims. And as long as victims contribute to a peaceful coexistence, that's fine. The problem is that victims and suffering also emphasize quite frequently questions of vengeance, questions of revenge. They inform a great deal of nationalist ideology. And when we come to conflict, we have no practices of actually questioning or interrogating the role of victims in nationalist ideologies. And I think that when we come, so there is a real dissonance, intellectual dissonance, between the idea of managing diversity and validating victims. The mechanisms that transitional justice advocate, underscore, is primarily the Truth Commission and the trials, the questions of fighting impunity. Now, I know there are other mechanisms, and I know you know, and we will talk, but by and large, those are the leading mechanisms that actually capture the public attention more than anything else. But those are only useful in a relatively narrow lens, in a relatively narrow sphere, and are not adequate in terms of bringing groups together, in terms of managing the diversity that informs the kind of conflicts that lead to genocide. And General Dallaire started this morning by talking about the baggage that we have when we engage in all of these, the baggage that comes in all of these conflicts. Transitional justice is primarily capable in addressing the living survivors, the violations that are immediately both punishing the perpetrators that are alive and responding to the violations of the very recent past. But the baggage that Dallaire was speaking about, the baggage that involves conflicts, are often much longer term than that. And that brings me to the second part of my comments, which I wanted to emphasize, and that is that whether it's transitional justice, responsibility to protect, prevention, whatever the categories of the professional tools that exist, that they need to expand the time horizon which needs to be included in our perspective. So, and by that I mean to actually try and shape and manage, if you will, but try and shape and influence the identity of the protagonists in conflicts that pose a risk of genocide, of crime, of atrocities. In those cases where nationalist ideology is informed by fear, by hate, by nationalist mythologies, there has to be a format, there has to be new area of engagement that will actually respond to these kinds of fears and will enable to respond to them by creating new kind of knowledge, by bringing the two sides together to speak to each other, by engaging historical methodologies that address and demythologize a lot of the fears and the disinformation that exists within within groups. For that, there needs to be a new approach. It is not, so first of all, it's not something that needs to be invented. That's perhaps a point that needs to be made. There's a lot of work that is being done by civil society primarily that actually challenges the nationalist myth in very many societies. So the international component of that is actually, could be to underscore and to give support to these kinds of organizations and advocacy that shows the responsibility of various groups in a country, of various states, to atrocities that happen within their regions. So it's not of indicting other countries, but actually validating groups and academics that are self-critical of the national legacy of a particular country. To make it very concrete, reputedly, although it's not true, the first genocide in the 20th century was the Armenian genocide. So the role of Turkish society today in pushing for Turkey's acknowledgement of its responsibility to the genocide is the kind of things that I mean by engaging by civil society, that engages the historical legacy that actually informs the contemporary conflicts. This is not something about impunity. Nobody is going to be punished for those issues. This is not something that victims' testimony, although descendants of victims can certainly contribute to it, but the methodology is a much more historical methodology. There is oral histories. There are different ways in which you can get to it, which needs to be included in questions of in the toolkits, if you want, but more importantly, in creating a new field that brings into conversation the two groups that go beyond just establishing, so to speak, the truth, because there are different truths for these groups, and those have to show empathy and recognition for the suffering, no doubt, but also for the complexity of many of those conflicts. This ought to be done in different methodologies. It is done through commemorations, through memorialization, through education, including questions of textbooks that, as you probably familiar with, in some cases are at the heart of a national conflict. Exactly what is the textbook going to be included? Most famously, perhaps, between Japan, China, and Korea. So those are all areas where long-term historical conflict informs contemporary politics, but is not recognized by the international community as a tool for conflict resolution. And I think that when we talk about prevention, my perspective would be that we need to expand the time horizon much more than to the immediate violence that we face or the immediate violence of the past, but actually include the full relations and the full memory that engages the parties, the stakeholders in context. When in the 90s the wars in Yugoslavia took place, very much the Croats and the Serbs were refighting the memories of World War II. The fact that nothing is done to actually dismantle the misconceptions about Chetniks and the various memories that exist within Serbia as a victims group, rather than as a question of perpetrator, is something that needs to be included, that goes way beyond the charge of international tribunals or even domestic tribunals. And transitional justice is more appropriate, at least has been so far more appropriate, as a domestic mechanism, and we can see that very successfully in many cases. But as a regional approach, for instance, the inability so far to create a truth commission within the former Yugoslavia is a good example to where the tension, the international consideration that exists with regard to the tools that we are familiar with, and the need to include a more comprehensive, chronologically and spatial approach creates a tension. And I think I'll conclude by that. Thank you.
Thank you so much, Elazar. Our next panelist is Pablo de Greiff. Pablo de Greiff is the Director of Research at ICTJ in New York. In 2012, he was appointed by the United Nations Human Rights Council to serve as the first special rapporteur on the promotion of truth, justice, reparation, and guarantees of non-recurrence. Born in Colombia, he graduated from Yale University and from Northwestern. He is also the author of a number of articles, including his latest, Theorizing Transitional Justice. Mr. Greiff has been an advisor to different transitional justice bodies in Peru, Guatemala, Morocco, Colombia, and the Philippines. He also served as an advisor to the World Bank on the process leading to the World Development Report in 2011, Conflict, Security, and Development, which many of us rely on regularly.
Thank you very much. I would like to start by thanking the Auschwitz Institute and Cardozo for the very kind invitation. Despite the fact that I do not consider myself to be a genocide prevention expert by any stretch of the imagination. I'm also very pleased to be here sharing the table with friends and to be around both friends and people who know about the topic a lot more than I do. I want at some point I will address a few of the remarks that Elazar made, but I would like to start with a series of acknowledgements and disclaimers, some of which go to points related to Elazar's intervention. The first one, and perhaps at the broadest level of generality, sociologists are fond of drawing a distinction between interventions at the level of society, of culture, and of personality structures. And I think that it has to be acknowledged that transitional justice concentrates most of its efforts on interventions at the institutional level, at the social level. And of course, for anyone that knows anything about mass atrocity and genocide, we have to start by acknowledging that, for example, the sort of underlying phenomena that facilitate a genocide will not be fully addressed or overcome if you limit interventions on the institutional sphere, that there ought to be accompanying interventions at the level of personality structure and at the level of culture, which are not the main subject of transitional justice, but which will be necessary. The second comment has to do with the fact that I think that transitional justice over a very, very short period of time, about 20 to 30 years, has managed to accomplish what I take to be very significant things. Some of them including, for example, the fact that the field managed to consolidate itself, which should have not been taken for granted at all. So anyone who knows anything about the history of transitional justice and remembers the old debates of truth versus justice, for example, will of course remember that at one point the four measures that are now conceived to be the core of a comprehensive transitional justice policy, which are part of the title of the mandate that I now hold for the United Nations, a really unwieldy and not very apt title, among other reasons because I cannot use business cards, but I need a scroll. Namely, truth, justice, reparations, and guarantees of non-recurrence. Anyone who remembers the history would remember that for the first 2 decades of the existence of the field, those were not seen to be complementary, but rather competing measures. So the fact that the field managed to stave off the centrifugal forces that characterized the development of the field would have to acknowledge that this is, in a certain sense, an accomplishment. Right? So the Secretary General's 2004 report already talks about transitional justice in terms of the four elements, and not just as a simple list, but as part of a comprehensive approach to transitional justice. The resolution that creates, the Human Rights Council resolution that creates the mandate, insists on the importance of taking a comprehensive approach to the topic. In any case, the short point that I'm making is that this is one of the accomplishments of the field. The second accomplishment that is worth pointing out is that transitional justice has managed to normalize itself. And by that I mean that it is now the habitual response that the international community, as well as some national governments, gravitate towards in situations of transition. Now, but this accomplishment, which again should not have been taken for granted, could not have been taken for granted 15 years ago, also represents two challenges. Because remember that I said that I would begin by a series of disclaimers. So this is where the disclaimer comes. This achievement of the normalization of the field also raises a very, very significant challenge that leads me to partial agreement with Elazar, and that I put in the following terms. Transitional justice historically found its place of origins in post-authoritarian transitions. The paradigm, however, has migrated very rapidly towards post-conflict transitions, and I think that there are very serious abiding questions about the adequacy of that sort of transplant. There are some characteristics of the post-authoritarian contexts that explain why it made sense to think about these four measures as adequate measures of redress in a post-authoritarian context that do not necessarily obtain in the post-conflict contexts. And let me mention primarily two. First, there is an issue about degrees of institutionalization. The post-authoritarian contexts were contexts of very, very high horizontal and vertical institutionalization. And by that I mean that, for example, in Argentina and Chile, and we will hear about some of these cases later on, the institutions of the state not only covered the totality of the national territories, of course not to the same degree in terms of the provision of services, but not necessarily out of a lack of capacity, but rather to some extent as a matter of choice. But furthermore, the institutions of the state already regulated most of the significant spheres of the interactions between citizens and the institutions of the state. These were not states with huge legal vacuums. Secondly, the types of crimes, the types of violations that needed redress in the post-authoritarian settings were of a particular type, namely the violations that very, very powerful and abusive state institutions are prone to engage in when not checked. Now, when you move towards the post-conflict context, neither of those two characteristics obtain. In the DRC, it is not true at all that the institutions of the state cover the whole of the territory of the state. And this is true in Burundi, this is true in Rwanda, it is even true in Colombia, right? Secondly, the types of violations that need to be redressed in the post-conflict settings are very different from the types of violations that need to be redressed in the post-authoritarian settings. both the kind but also the number of agents of violence are radically different in the two contexts. And I think that there is a lot of work that needs to be done in clarifying how to make effective the implementation of transitional justice measures in contexts that are very, very different from the context in which they found their place of origin. Elazar, interestingly, also mentions, and with this I agree as well, the difficulties in the implementation of transitional justice measures across national borders. And I think that this is something that deserves much more consideration. The Balkans, East Timor with respect to Indonesia, Aceh with respect to Indonesia, the eventual resolution of the Israel-Palestine conflict to the extent that there may be some room for the implementation of some transitional justice measures, Kosovo, the Balkans. I mean, the list of places where the cross-border implementation of the measures may be an important issue and where the field itself is not prepared to do that yet, is not short, and it is not closed. I suspect that the list will keep growing. So this is another piece of agreement with Elazar. Now, because I have already consumed 5 minutes, I want to get to addressing some of the issues that explain the interest of this conference. But there is a bit of an awkward a consideration that needs to be included, and that is transitional justice measures are typically redress mechanisms, right? They are applied usually after the fact, and the meeting explicitly asks us to consider what is their preventive, in other words, ex ante function. I think, and this was the last disclaimer that I wanted to make, there is a sense in which transitional justice, because of its success and its rapid migration, is a bit of an undisciplined field. I think that all fields of intervention are undisciplined in the sense that there are very few people who worry about doing a proper functional analysis that tries to clarify what is it in the design of the measures that a particular field has available that explains the results, the potential results that are attributed to the implementation of the measures. That exercise is very, very rarely engaged in. Justice-related work and human rights-related work, at least in part because of the good intentions that motivate work in those areas, I think is particularly bad at engaging in serious functional analysis. I do not want to replicate this measure, so I'm going to lay out a very, very short argument that tries to link transitional justice with the aims that it can arguably achieve, try to explain how the measures work, and try to derive some consequences about the potential use of transitional justice for genocide prevention. Since I have to do this in 3 minutes, it will be nothing more than a sketch. All sorts of ends have been attributed to the implementation of transitional justice measures. Transitional justice measures have been said to accomplish all sorts of wonderful things: healing victims, promoting reconciliation, strengthening the rule of law, all sorts of wonderful things, which are, of course, very, very desirable. The question is how they can be thought to accomplish any of those things, and what happens if you try to do even rapid functional analysis. What would you have to conclude about the real potential of the measures? I think that this exercise is incredibly healthy. because it promotes, on the one hand, a certain type of modesty that the field, I think, needs about what it can accomplish, but secondly, a certain type of fairness in the assessment of impact, because it would be unfair to blame a field for failing to achieve ends that it was never designed to achieve. And this is where I start parting ways with Elazar. Transitional justice, strictly speaking, is not a post-conflict or a conflict resolution tool. This is a tool to overcome impunity gaps that arise out of situations in which massive human rights are abused. And I think that we ought to start there. There are three things that I think transitional justice measures responsibly can be claimed to do. First, they can provide some degree of recognition to victims, not just in terms of the suffering that they endured, but more importantly, in terms of the fact that victims are also rights bearers. Secondly, transitional justice can make a contribution to strengthening the degree of confidence in state institutions after a period of massive breakdown. And third, transitional justice measures can contribute to strengthening the rule of law. There are ways of tracing causal pathways that explain the possibility, not the certainty, but the possibility of linking the implementation of the measures with those three goals. But because I am running out of time, I will mention two important social mechanisms that would be a part of that explanation. The first one, transitional justice measures work to the extent that they do because they are effective mechanisms of norm affirmation. In other words, all the measures, truth, justice, reparations, and guarantees of non-recurrence, are meant to signal the fact that the violation of certain basic norms is not inconsequential. Secondly, transitional justice measures work to the extent that they have the power to articulate and to disarticulate certain social groups. In every country in which transitional justice measures have been placed in the agenda, a plethora of civil society organizations have formed almost immediately. Peru went from very, very few human rights organizations to 180 after the creation of the Truth Commission. That was followed by the formation of networks of civil society organizations. And the general point, again, is that that was considered to be a mere side effect, I think that we should now consider to be a perfectly predictable consequence of the implementation of the measures. Civil society organizations are catalyzed through the discussion, let alone the implementation of transitional justice measures. And similarly, transitional justice measures contribute to the dismantling of some organizations, including paramilitary and parastatal groups. Both things are important, and in both mechanisms, the capacity to affirm norms and the capacity to articulate and to disarticulate civil society organizations, I think that there is the potential of the measures playing some role in the prevention of future abuse. And I will stop here. Thank you very much.
Thank you very much. Our next speaker is Fabián Oddone. Mr. Oddone is a lawyer and a member of the Foreign Service of Argentina. He is currently posted at the Argentine Embassy in Brazil. He also served at the mission to the Organization of American States in Washington and the embassies in Colombia and Venezuela. In Buenos Aires, he worked at the Department of Human Rights and was involved in a project of developing a national action plan against discrimination. He has worked on issues related to genocide prevention and took part in the first seminar organized by the Auschwitz Institute for Peace and Reconciliation in 2008 and was also an instructor there in 2011. Mr. Oddone.
Thank you very much. thank you for having invited me. It's a pleasure for me to share this panel with such huge personalities in terms of transitional justice. And I'm going to limit just to tell you some notes about our process of dealing with the past in Argentina, and maybe trying to explain how we learned from this experience and how we grounded our new agenda on human rights regarding our past and trying to battle against impunity. Let me start by telling you that the panel says why the transitional justice was so important, is important to our country. In the case of Argentina, I could say that not only modified the agenda of human rights, but changed it dramatically and help us to face new challenges, not only in terms of battling against impunity, but only to look at the new challenges we are hoping to cope with, like prevention of genocide. Let me start with telling two words about the dictatorship in Argentina that took place between 1976 and 1983. And because of this dictatorship, at least 30,000 people just disappeared, which means now we know that they were tortured, they were killed, and sometimes they were even thrown alive from out of planes. And because of this dictatorship, also like 500 babies were born in captivity. Many thousand were forced to exile, and many others were also illegally detained. And well, luckily for them, they were released later. From the very beginning, there was a clear demand from the family of the victims trying to know what had happened to their beloved ones. And to say in Spanish, the original word was aparición con vida y castigo a los culpables, which is a free translation, something like we want them back alive and we want the perpetrators to be punished. So even before the end of the dictatorship, there were two very, very important notes in the process of the revision of the past in Argentina. It was first was the searching for truth, and secondly was the justice. I mean, all the dealing with the past in Argentina was talking about justice and searching for truth. And of course, the main actor of this process was the civil society. Maybe it was one of the best creations of the Argentine society, the movement of human rights. It was so powerful, this movement. The civil society was so powerful, so the effects, the role it was called to have in the following 3 decades was really important. It was essential. And so we know that there are many possible ways of dealing with the past. Every country has its own circumstances to attend, like historical patterns or cultural patterns. But in the case of Argentina, there was no doubt since the very beginning that we had to prosecute the perpetrators, and we had to know the truth. And apart from that, there was also a wide policy of reparations and, of course, the construction of the memory. The first years of this process we were very busy trying to battle against impunity. The impunity was a main subject of these almost 3 decades, and because it was not an easy process, we had many obstacles. We had to battle against laws of impunity, general pardons, and starting again. But at the end of these 3 decades, we can say that we have gone very, very far. There are more than 1,100 people now convicted or waiting for convictions. They are on trials. There are many, many trials at this moment in progress. But this battle against impunity was also a very good basis for a new agenda on human rights. Because of looking at our past, because of recognizing that we didn't have a future without looking at our past, without knowing who we are and who we are coming from, we couldn't maybe do something that we have done during these years. The first path to this new agenda was trying to make a diagnosis of ourselves, of our patterns of discrimination, of knowing why we have this tendency to political violence, why we have this tendency to authoritarian practices. And it was a very honest, it was a very comprehensive diagnosis. This plan against discrimination was maybe the first path after this first moment of just battling against impunity. And because of this plan of against discrimination, we could have more than 200 recommendations on politics that should be implemented, that had to be implemented. And it was approved, this plan, by the government, and because of that, we could also go ahead with some debates, with very difficult debates, that, and I think this is one of the results of this endless process of trying to know the truth and trying to really discover why we had reached such a point. We have arrived to this point of committing a genocide in Argentina. Well, after that, the consensus on some subjects were really easy. And for instance, like 2 years ago, we had to discuss the egalitarian marriage, which is a very sensitive subject in many countries in the world at this moment. Many countries are still discussing about this institution. And it was really easy in Argentina to pass this law and to pass other laws also, like the new law in immigration, for instance, which is a kind of a revolutionary law for Argentina, which goes against many of our very bad traditions on discrimination. And also we have a new law of protection for refugees. We have also new laws on gender identity. And there are many other discussions at this moment that are taking place in Argentina, and they are all, we think they are all as a consequence of this this first battle against impunity, which led us to go deeper in the causes in order not to have this type of situation in the future again. Of course, we think that apart from these debates that are taking place in Argentina, we think that the international community can also have an essential role in the process of democratization in our country. For instance, we consider that by empowering the international community, we can also create a kind of system of preventive medicines. I mean, the more treaties we sign in terms of human rights, the more obligations we assume if we allow the international tribunals to have sentences against the state, and we have recommendations, so we have the opportunity to improve our legal system. And it's also a very good justification for many people in the country that sometimes don't agree on going ahead with some changes in the legislation that really affect them, deeply affect them. And it happened before, and it's happening, and of course it's going to happen in the future. So we see there is the more we know about our past, the more we know about the crimes that have been committed in Argentina, the testimonies of the victims, the role of the movement of human rights, disseminating the information, well, the more elements we have to work on in order to improve our agenda of human rights also. And after 3 decades, we could say, well, maybe at the end of the decade, and comparing to many other countries, we have gone really far. But we consider that the job is not done at all. I mean, we have gone far, but we have very, very difficult challenges ahead yet, like prevention. I mean, we know because we have proved that because of this our plan against discrimination, because our fight against impunity, that many of the causes of the violence in the society are deeply rooted in the society. So we have to eradicate them. And the only way of eradicating it is by transforming every citizen in Argentina into an essential part of an early warning system, in order everybody should be aware that has an essential role in terms of preventing the recurrence of any genocide, of any violence in the future. So I think at this moment we have again a powerful force. We have power. Okay. We can be helped by the international community. We see many initiatives at this moment taking place in the world, and we are trying to use all of them in our favor. For instance, the action taken by the Auschwitz Institute, we are partnered with them. We have been partnered for over 5 years now, and they are really learning. They are teaching us how to make advanced diagnosis, how to try to improve our capacities in prevention, how to educate our officials, how to educate the population at large. And maybe we have a long way, but we think we are in the correct way till now.
Thank you very much, Fabián. Our final panelist is Sheri Rosenberg. Sheri is an assistant clinical professor of law and director of the Human Rights and Genocide Clinic and Program in Holocaust, Genocide, and Human Rights Studies at Cardozo School of Law. She's worked in the areas of civil rights and international human rights with a specific focus on issues of discrimination, equality, and genocide. In 2000, the U.S. Department of State selected Professor Rosenberg to work for the Human Rights Chamber, a quasi-international court established under the Dayton Peace Agreement in Sarajevo, Bosnia, and Herzegovina. Her research interests include equality and non-discrimination in international law, minority rights, refugee law, transitional justice, and genocide prevention. Professor Rosenberg has written prolifically on this issue and on the Responsibly Protect, so it's an honor to introduce her.
Thanks. Thank you, Naomi. I appreciate that. I don't know where to start because I have some comments and I'm so tempted to respond. So I'm
Maybe do a mix of both.
Well, I'm going to see it. They don't exactly mix well, but I'm going to step back for a minute and thank Tibigalis for encouraging me to try to organize this conference and the book and present on this panel all at the same time, because that would have been quite a challenge, which is why my head is sort of spinning. But I'm going to make just one comment that I think sort of summarizes a little bit. I mean, I think, and it's always hard to follow Fabián, who I think is a tremendous speaker and gives a really positive view on the way in which transitional justice can work in post-authoritarian regimes, though it, it was very much internally sort of homegrown with assistance from the international community. As Pablo pointed out, the battle against impunity, transitional justice really grew out of a response to authoritarian regimes like Argentina and even Nazi Germany. And to follow up on what Elazar's suggesting is that I agree that with his point that it doesn't work as well, and I'm going to talk specifically now about the International Criminal Court. That's what I was tasked with talking about, which is slightly different than, let's say, the battle against impunity in Argentina by Argentinian courts. I don't think it works quite as well for the reasons Elazar points out when it comes to questions of diversity management and dealing with the multiple truths that exist in places like the former Yugoslavia or in Rwanda, for example. So, for example, in the former Yugoslavia, it remains to this date, and I'll talk about Bosnia specifically, there are multiple truths. Education is still taught differently in segregated schools. When someone of, let's say, the Croat ethnicity is convicted before the International Criminal Tribunal for the former Yugoslavia, Croats generally, and I'm making sweeping generalizations, we have a short amount of time, but generally will claim that the international community is basically sort of out to get us. They don't get it. They don't understand our truth. And at least for now, and let me just back up and say I'm a proponent. How can you not be a proponent? The International Criminal Court and the fight against impunity is clearly necessary. But what I would like to do with that sort of background in mind is take apart a little bit the justifications that are given for why impunity is important and why it works. Since Nuremberg, there has been an ex post punishment approach to preventing or ending mass atrocity, rather than an ex ante effective policy of prevention. And again, I'm going to sort of flip back a little bit to what Pablo was saying and bring it back to what General Dallaire was saying, where he made a plea for really connecting the two, really understanding that there is no prevention without appropriate rebuilding that takes not only the suffering, to pick up on Elazar, of the victims, but of the entire community into account. So, in fact, since the time of Louis XIV, if not before, criminal punishment has continuously captured the public imagination. I mean, there's no question about that. When I teach classes here on citizenship, equality, and human rights, or various other classes, people want to talk about international criminal law. Criminal law is sort of sexy for some reason, and it continues to always, capture the public imagination, and that's great in some ways. To date, it has become an integral part of international relations in general, and that's all a good thing. As part of this evolution, we've seen the establishment of the International Criminal Court, a good thing. The International Criminal Court is born out of, I think in part, this sort of human rights imperatives, which demand that, in quote, individuals have a right to know, and that there's this notion that there's individuals, I think, and Pablo referred to this, victims have rights. They have a right to accountability, they have a right to justice. And of course, again, that's a positive development overall. But I want to just suggest that continued focus on trials has the potential to short-circuit our understanding of particular prevention methods that should be utilized in specific situations. And in this brief time, I'm going to just proceed in the following way. One, I want to just very briefly, and this is sort of thumbnail sketch, and sort of just throw it out there for people who are interested to follow up on these questions. I want to briefly analyze the oft unanalyzed assumption that punishment prevents. Now, I'm agnostic sort of on the question in the short term, and I am not going to get into the argument of whether it does or it doesn't. I simply want to lay out, primarily from a legal perspective, the arguments that it does prevent. I just want to lay out those arguments and let us think about that for a minute. Second, in the process, I want to connect up a little bit international criminal law with the language of primarily the social scientists who speak of prevention in respect of structural prevention which is long-term prevention that seeks to strengthen a state's resilience against mass atrocities, e.g. rule of law, institution building, economic development, and so on, and proximate prevention, which is short-term prevention tools that are utilized when atrocities are underway or imminent. And I want to put forward sort of a tentative argument that as the International Criminal Court has been utilized thus far, it has the potential to fill a role that perhaps needs to be further developed, and that's this notion of midterm prevention, which is that, and it deals with the point in the process of unfolding atrocities where the examination of foreseeable consequences, if you examine sort of foreseeable consequences, establishes a real risk that exceptional grave human rights violations that we all know about are occurring or could occur in the future. And I'll flesh this out a little bit. And finally, I simply want to make a suggestion for undertaking a rigorous analysis of the trade-offs between the human rights imperatives of victims of atrocity or would-be atrocity that are at hand when we're looking at the numerous human rights imperatives that victims need or that societies need, and where does international criminal justice, the ICC, fit in to this set of human rights imperatives. So briefly, it's all very thumbnail sketch. It'll be in the book that'll come out in 2014, I hope. When people talk about, if you look at the literature, when people talk about the relationship between the International Criminal Court, or ICC justice, and prevention, it generally takes two forms. One, they talk about immediate deterrence, right? The immediate effect that the International Criminal Court could have on the calculations of actors who are considering committing horrible crimes. And functionally, it works in two ways. You have indictments and you have arrest warrants, right? Now, immediate deterrence in sort of national, and I'm no expert, I'm no criminal law expert, but generally speaking, immediate deterrence rests on two assumptions. You have certainty of being prosecuted and the severity of the punishment. And I'm really thumbnail sketching much broader arguments. And some argue, and at this point where more indictees rather than fewer remain at large, the notion is that the likelihood of prosecution will deter them from future criminal activity regardless of detention does not really exist. So you have a lot of skeptics because of the fact that you have basically unfulfilled indictments and Bashir, traveling around to states all over Africa. And right now, even though there's an arrest warrant out for him, and in the Kenyan elections that are coming up in March, in just a couple of weeks, you have two individuals who could very well win in those elections who have been indicted by the International Criminal Court. So some argue, taking into account the certainty of prosecution and severity of punishment, as well as particular individuals' preference for risk, because part of this involves whether or not the individual is really willing to take a risk in a mass atrocity setting. International criminal justice is unlikely to deter in the immediate. And in fact, some argue that it could exacerbate the situation in certain instances. The second way, so question mark on immediate deterrence, that doesn't mean throw the baby out with the bathwater. I'm simply suggesting that we look critically, and I think Pablo also made a suggestion that we begin to look critically. The second way in which the ICC works with respect to immediate deterrence is direct warnings and signals. And I think Juan Mendez referred to that earlier, one instance of that. But an example of that would be when violence broke out in Cote d'Ivoire after the recent disputed election. The prosecutor of the ICC publicly warned an individual that his incitements to violence might be publicly prosecuted by the International Criminal Court. Likewise, Juan Mendez, he's not a prosecutor at the ICC, but he also talked about a situation where in Guinea in 2009, there was a lot of incitement going on. He warned the individuals involved, continue to engage in this kind of inciting behavior, and you can land yourself before the International Criminal Court. And to them, it had some effect. And then I already mentioned you have the issuing. Then secondly, you have the issuing of arrest warrants, which is also a direct signal. in ongoing conflict. So you had the issuing of arrest warrants in Darfur while the crimes against humanity or atrocities were occurring, and in Libya in the midst of ongoing conflict. And this establishes the idea that the ICC is not solely, doesn't see itself as solely acting as an ex post facto mechanism, but also as an instrument of constraint on ongoing violence, intended to change the calculations of the actors. It doesn't seem to have done that, question mark, okay, and skeptics, fine. So that's immediate deterrence. Long-term deterrence subdivided into two ideas. One is this idea of complementarity that I think a number of you are already quite familiar with, so again, just a thumbnail. It's basically interpreted as a positive force for empowering national courts. The International Criminal Court will not hear a case if a national court is both able and willing to hear the case. The former prosecutor has stated more than once that an absence of trials in the International Criminal Court, if it's a consequence of the regular functioning of national courts, would signal a major success for the International Criminal Court. So I guess one could argue that the International Criminal Court's goal is to put itself out of business. Very little empirical evidence to date on this point, though there is some research starting. And then, just to follow up on what Pablo said, so I don't have to really go on, the second idea in terms of long-term deterrence is this idea of norm proliferation, contributing to the establishment of a culture that considers the commission of atrocities unacceptable. And over time, international criminal justice, this is the argument, will instill, in quote, unconscious inhibitions against crime or a habit of lawfulness in societies generally. And finally, this notion of expressivism, which is related to norm building. An example of that is in the Lubanga trial, where you had a conviction of Lubanga. He was indicted and convicted on 3 counts of crimes against humanity for the use of child soldiers. And some argue, why did the court focus, among all the crimes, why did the court focus on the use of child soldiers? Some argue that it's because of the what that expresses. It expresses to a number of countries that don't necessarily have this norm in place that the use of child soldiers will no longer be accepted. You cannot use child soldiers in your wars. That's not fully accepted in all societies, so it was used for its expressive value. So that's a real thumbnail sketch of arguments that are put forward for how the ICC works in terms of prevention. And I just want to conclude in, I think, the minute or two I have left. I think the connection between international prosecutions and actual deterrence of future atrocities by the International Criminal Court, I'm not talking about homegrown institutions, is at best a plausible assumption. Actual experience with these efforts is not encouraging. Beginning in 1941, the United States and the United Kingdom issued a series of highly publicized warnings that violation of the laws of war would be punished. Allied radio and press explicitly warned the German population that there would be criminal trials for, in quote, the systematic murder of the Jews of Europe. Similarly, in the former Yugoslavia, atrocities continued in spite of international criminal prosecutions. Srebrenica happened 2 years after the ICTY was established. There remain central challenges to the developing field of international criminal justice. And I just want to conclude by saying that, and this is not to say that the ICC has no role to play in atrocity prevention, but rather we should be modest about what it can achieve, and we should balance what we think about all the different tools in the transitional justice toolbox, or the prevention toolbox, or whatever field you're coming from, balance it against all the human rights imperatives. And finally, we in the legal and the prevention communities and the TJ communities should not be trying to foist the prevention role on the court in an attempt to mitigate each community's weaknesses and salvage each community's reputation, instead of focusing on how to best achieve our aims of ex-ante prevention. Thank you.
Thank you very much, Sheri. I think you ended it on a really important note. I just wanted to take a quick minute, just kind of reflecting on our experiences working around R2P, it seems like we regard transitional justice as part of the quote-unquote R2P toolbox and really critical to prevention, yet we often don't really get down to the nuts and bolts of what we actually mean, especially when we set expectations high that this can actually play a deterrent or preventive role. And I thought there were a couple of things that each of the speakers touched on that's worth highlighting. One, it struck me that both Elazar and Pablo both spoke, although coming at it from a different perspective, about the need for there to be parallel processes underway when you use transitional justice as a measure, be it for prevention, reconciliation, any of the kind of intended goals that you achieve. And that's the same with so many of the R2P measures that we use. Targeted sanctions may be effective in one case, but you need to have something else happening in conjunction with that. So it's problematic to look at these as standalones. Also, the need to kind of set expectations where there's clearly an inherent tension because aspirations are so high. And we really want the responsibility to protect to be effective. We want transitional justice to bring closure to individuals and to help with the reconciliation process. It also struck me that each of you really highlighted the need for self-reflection and questioning throughout the process, that there are no givens, and that it's important to highlight the disjunction. I thought when Pablo said it was very clear between using transitional justice to deal with situations after the fact with authoritarian regimes, but also in post-conflict situations. What are the tensions there? And it made me think, I'm actually running from here to go on a plane to Kenya, and it really raised a number of questions for me, because Kenya right now, obviously they've got their election 1 week from now. That is a country where there's been rampant impunity. It's not just impunity for the 07 and 08 post-electoral violence that left 1,300 dead, but impunity really for over 100 years of human rights violations that have been perpetrated for numerous actors. And if you get down and you talk to victims, even that notion of identifying as a victim is something that is fraught with a lot of different issues. But each of the so-called victim communities have their own narrative. And it's fascinating because so much of it is passed down generationally. So how do you confront that, and how do you deal with that? And how, in the absence of trials, in the absence of a truly functioning Truth and Reconciliation Commission, and with the presence of elites and also even political officials who are implicated in some of the more recent violence and human rights violations, how do you mobilize the political will in that type of situation, in this kind of post-conflict type of situation, to take the first steps that are needed for transitional justice? And I think the case of Argentina presents kind of an interesting counterpoint to that. But how do you mobilize political will and timing? When do you begin to employ some of these measures? And how do you begin to employ that kind of parallel process of changing the culture and the personality structures? And then just finally, I thought that I think Sheri used the notion of what's sexy. And it's interesting how what's sexy drives policy and what's sexy drives scholarship often. And sometimes I think it's really important and incumbent on all of us working on these issues is to explicitly look for what's not sexy. Because in those gaps, we might actually find some very innovative ways to kind of ensure that transitional justice can have an important prevention role. And I thought I would just kind of end, Sheri mentioned on the ICC question. It's fascinating, again, in the case of Kenya, because it seems as though national leaders have heard that message quite strongly, that they will be held accountable. And it's a very politicized issue right now. But that's at the national level. The ICC doesn't address the legal vacuum that I think Pablo mentioned that exists really at the local level. And therefore, the people who are inclined to take up arms today to contest the outcome of the elections will be at the local level, and they will be the ones that have never had any experience with any form of transitional justice. So how do we then, as the international community, begin to strengthen the rule of law to help address those particular threats? So I think, just as a starting point and question for you, I guess it would be kind of around mobilizing political will in situations. And most of the R2P cases that we're looking at now are cases where the government in question or key actors remain in power. So how does transitional justice play a role in that particular stage? And then we'll open it up to questions for everyone. We have around half an hour. I don't know if there's anyone who would like to kind of tackle the political will question. Pablo.
I will take a stab at it, but not because I have a magic bullet, of course. Look, there is also a bit of a historical act of amnesia here. Transitional justice measures were always implemented in a post-transitional situation. In other words, there was no need to ask the question about how to muster the political will for current regimes to implement measures that clearly did not serve the interest of the present leaders. Right? They were implemented after the fall of regimes. One of the difficulties with the proliferation of transitional justice measures, and again, perhaps an extreme case of this, is the implementation of the measures not in post-authoritarian contexts, not even in post-conflict contexts, but in situations of current contexts, again, like in Colombia, for example. And that, of course, generates the question of political will with a vengeance. I think that there is a legitimate question that needs to be raised, not just about how to improve the effectiveness of the measures in the post-conflict settings, but also a very urgent question about the timing and the sequencing of the measures in situations of ongoing conflict and even in situations of recently concluded conflict. Now, having said that, however, I want to go back to a sort of positive message that takes off from a comment that Sheri made about deterrence. I have always felt that the deterrent argument is the weakest possible argument for international criminal law, and even for some of the other measures in the transitional justice tool bag, as it were. I think that there's a stronger preventive measure to be made that has to do with the last point that I was trying to make in the intervention about the power of the measures to disarticulate certain types of social networks. The reason why vetting is important, I think, has very little to do with the deterrent signal of vetting. Vetting is important not because it sends the signal that there is a great loss to be associated, to be expected with participating in certain types of illegal action. Vetting is important because it dismantles networks of criminality. So in other words, I think that it's much better to think about transitional justice measures on an anti-mafia analogy, as it were, than on a pure deterrent basis. I think that the deterrent base is weak. I think that the dismantling argument is significantly stronger, and that there are some successes that can actually be pointed to. The second comment has to do with Luis Moreno Campo was fond of saying that the importance of the court didn't simply have to do with the absence of cases reaching the international court. The importance of the court from him had to do with the fact that almost without exception, armies around the world had asked for training from the court about how not to fall afoul of international humanitarian law, and that was a much better way of explaining the effectiveness of the court than any success in any of the trials that the court could be expected to have. So again, being modest about the sorts of things that we can expect, I am not at all pessimistic or a masochist or a cynic about even the preventive role of some of these measures, but they cannot be overstated either.
Let me say just in response to what Pablo was saying, the conflict resolution community is by and large forward-looking. It doesn't include the past. The only game in town with regard to facing the past is basically transitional justice. And transitional justice presents, on the one hand, the inflationary expectations that you presented at the very beginning, but also the more focused approach that you think that that in order to be effective, it has to narrow the focus down. That leaves a huge space that is not addressed. And I think this is the challenge in terms of expanding the agenda, is how to address those areas that need to include, to address the past, but are not coming under the category of what can be effectively expected from the tools or the mechanism that the transitional justice can judicially take upon itself. So in that regard, the past has to be incorporated integrally into the building of a democracy. And that includes a lot of other components in the society that don't find a space at the moment within the discussions, whether about preventing or rebuilding or whatever other categories that we talk about post and. So in that regard, I think that it's a much more diffused situation, but also gets away from the timing question, because you never, once you deal with civil society organizations, you don't need necessarily to have a particularly rigid sequencing. People operate at different level, and society is diverse enough to include stakeholders that are more ready to engage in interactions with the other or with the outgroup, even while the conflict is going on. So that can be a preparatory stage, rather than to wait and to ask whether historical dialogue has to, or whatever transitional dialogue has to start after the conflict or before the conflict ends. To a certain degree, it can do both. There's no need to choose one or the other. The question is, similar to human rights, it needs to legitimate new norms. And one of these norms is incorporating the past as an active tool in building democracy and building society in a post-conflict situation.
Thank you. Why don't we take some questions from the audience? Yes, ma'am. Is there a microphone? Oh, great. There's a microphone coming.
Very complex presentation, so complex comments, and I would really comment. I can put it in a form of a question, but I really want to put it in a form of a comment. Having worked very hard for the court, for the ICC to be born, right? And being inside all the processes rather than on the outside looking at it, I'm a little surprised that you already have a concluding judgment on its effectiveness, because it's just a baby, just born. But the one thing I'm feeling totally missing from the conversation, particularly because it hasn't happened yet, it will though, is the reparative aspect of the ICC. All of you spoke only of the punitive aspect of the ICC. That is what a judgment or an indictment might mean for deterrence or prevention. I think there is, those of us who have worked very hard and still do toward implementing the reparative aspect of the ICC. That is, it's the role of the victims in the ICC that makes it, as far as I'm concerned, the most unique institution, international criminal justice institution, has not been addressed here. Both in protection, yes, it's part of deterrence, but also participation, and most importantly, reparations. And again, one can argue that in reality, such as in the reality of not getting Bashir, even by countries that are member states, this is quite infuriating on a daily basis for those who care. The reality is also that indeed there isn't enough money, and most likely there'll never be enough money for meaningful reparations, a la the Western kind for victims. If one works them right, if one incorporates important principles of healing into reparations, into the whole reparative notion of the ICC, I believe in it very, very much. I would like you to address that.
Thank you. Why don't we take one more question at the same time? Yes, thank you.
Thank you. I think many of you spoke to the possible failings of international justice and the ICC. And I'm originally from Bosnia, and so I know a bit about that conflict. And my question is about individual accountability and immunity, especially in cases of widespread systematic sexual violence, when in many cases individuals are granted immunity so that higher officials or commanders or government officials could be prosecuted instead, but that leaves a bitterness, I think, in local populations when individuals don't feel that justice has been served, even though the international community may feel that justice has been served. So if you could speak to that at all.
Is there someone who would like to begin?
I can start just
Okay.
very, very briefly. Just to the first question, Yael, maybe I wasn't clear, but I specifically said I have no conclusions. I'm not foolish enough as to make any conclusions about whether it has succeeded or will succeed. So I just want to make sure that was clear in case anybody else thought that I've made conclusions about what the ICC can or cannot do. I agree. I did not address the reparative aspects. I had 10 minutes, a lot to say. Simply to say that we've just been working on a project now with the reparations unit at the ICC to draft a manual for 3 NGOs that are working in countries where the ICC is operating to translate for local NGOs what the hell it is the ICC is talking about. Because victims walk into their office and they have been, just as an example, subject to some kind of sexual violence. And it's kind of crazy. I mean, we drew up, I don't know if the 2 students who worked on that are here, but we literally drew up checklists, that were given to us in part, or we modeled them after checklists that the ICC has to determine whether these individuals were entitled to reparations under the International Criminal Court mandate, or rather, was it an issue of sexual violence that was committed as a form of domestic violence, in which case they need to go elsewhere to seek reparations, because they wouldn't fall necessarily within the mandate of the reparation. So we have been involved in it. If it wasn't addressed here, it was simply a matter of time. So I just wanted to respond to that. And in terms of individual accountability, just very quickly, I've heard what you've said, before. I've heard what you've said both in Bosnia, and I heard the same thing in Rwanda. We were in Rwanda in 2008 and asked a legal academic there who's working on these issues what she thought the contribution of the International Criminal Tribunal for Rwanda has been in Rwanda. And she said, basically for victims in Rwanda, nothing really. The most important thing that and again, don't get me wrong, I'm in favor. I simply think that it's important. I was not one of the people who advocated like Yael did. I'm not an insider, except for some little work here and there. So I have the ability to just sort of step back and do a critical analysis. It's easy to talk about all the good things that it's doing. I mean, I think we all know that. But the same thing in Rwanda. I mean, basically she said that it's done not much here. The most important thing that it's done is to let the international world, the international community know what happened here in Rwanda. That's one person's opinion. It's anecdotal.
Pablo, did you want to respond?
Yeah, about the importance of reparations, enough about this. I started my work on transitional justice doing many, many years of research and practice on reparations. So I think that reparations play a particularly important role within a transitional justice measure. Policy, at least in part because it is the measure that is supposed to be organized and implemented for the direct benefit of the victim. So criminal prosecutions, for example, may have very positive spillover effects in terms of dignification and the restoration of rights for victims. But this is a measure that is initially implemented against the victims. So reparations is very, very important for the victims. The panel itself, however, was on general transitional justice approaches and their contribution to prevention. Having said that, however, I have absolutely no reservation whatsoever in thinking, and if we had had more time, it would have been interesting to disaggregate the contribution to prevention that the different measures makes. But we didn't have no time. Having said that, there is absolutely no question in my mind about the centrality of the notion of reparations within a comprehensive policy. Now, I must say, however, recent experiences in the Middle East and Northern Africa, including the course of the discussions about the implementation of transitional justice in Tunis, for instance, suggests that it is also possible to overvalue within a comprehensive policy the role of reparations, and that it is always a question, at least in my mind, of guaranteeing that the four pillars of the policy are kept closely linked to one another. There was a question about immunity for lower-level perpetrators and the consequences that this might have in people's perceptions of justice. I think that, again, in order to be brief, the issue of linkages is one that I think needs to be stressed again and again, just as it would be a mistake to put all the efforts of transitional justice into one of its pillars, even if it's criminal prosecutions, the one that has the largest amount of backing, at least on the part of the international community. I think that it would be a mistake to select within the universe of potential people that could come up for prosecutions a single sliver of that universe. So, of course, the International Criminal Court can say that it will concentrate its efforts on the most responsible. After all, it is never expected, it was never expected to try everyone. For national courts, however, I think that, for example, there have been instances in which the pursuit of the same policy by national courts had led to what in the Argentinian case Jaime Malamud-Gotti argued was a pernicious effect, that if you concentrate prosecutions at the very top, you eventually end up sending the message that whoever is not prosecuted is innocent. And of course, that's not a message that you want to send when there is systemic crime that requires the collaboration of thousands of people across the ranks of the security and the armed forces. So there are dangers to this as well, and it's again a question of how to be even-handed in the distribution of efforts, not just prosecutorial, but otherwise, and not just transitional justice related, but other related, including conflict resolution, development, security sector reform, etc. But part of what I'm trying to argue against in my work is the effort to think that transitional justice measures or any particular kind of policy intervention exhausts the agenda of political and social transformation. I think that these are very important contributions, not always easy to link with one another, some of them with complicated, contradictory agendas, but nevertheless, the processes are so complex and the needs so vast that it would be disingenuous for anyone to think that through a single type of intervention, you will manage the changes that are truly required.
Thank you for that. We only have a couple minutes left, so I'd like to just end with Elazar providing his comments and responses, and then also Fabián, if you'd like to make some concluding remarks. Thank you.
Well, perhaps just to remind ourselves that when we talk about all of the whether it's transitional justice or the ICC, we're speaking about whatever the measures that are being taken only on symbolic measures. So the idea of whether we're looking at it as failure or as success is a matter of disposition rather than of the facts out there and what are the expectations. There's no way that in any of the cases that we're dealing with that there will be adequate justice. If there could have been an adequate measure, then it wouldn't be transitional justice. It would be just plain justice. If there could be post-conflict situations, whether the reparations in the West or not in the West, whether it's always symbolic, because the atrocities for which reparations are being offered or available are so horrific that in a normal society that would not even begin to scratch the surface of adequate compensation or adequate redress. So I think that it's important to remember that the symbolism of the measures that we're talking about is a symbolism that is aimed to restructure, rebuild the society. And with that, I think we need to have a more comprehensive perspective.
Thank you. Fabián?
Yes, let me finish. I was listening to them very carefully, and I think as I started that there is a very comprehensive menu in terms of transitional justice. Every country has to deal with their past in the way they can. In the case of Argentina, maybe we have gone far, and maybe, as I said, we are at the end of the process. But maybe also more than conclusion, I'm having now a new question. We now are trying to eradicate completely for a long-term process, and we are trying to think of every citizen as a part of an early warning system in thinking that this kind of violence must not be repeated at all in the future. This is a new, I haven't heard a lot about these possibilities of prevention as a new tool for transitional justice. We are going beyond the transitional justice, or we have to think something different for the future. And maybe it's a question, and I hope you only have 1 minute to
Thank you very much for that fascinating discussion, and I think we're now going to break for lunch. Daniel?
So before everyone gets up and starts moving around, I just want to tell you how lunch is going to work. We're going to go down to the registration table when you first walked in. Lunch is going to be $10, and then we're going to sit down, and there's going to be a presentation. We're going to be awarding Barbara Harf with the Raphael Lemkin Prize. So please make your way over to the registration table as soon as you can. Thank you.